Hey everyone, thanks for joining me. My name is Takhsh, an immigration attorney from Chicago. I've been doing this line of work for over 10 years, helping individuals and families maneuver their respective immigration journeys. So today I want to talk about one of our most common types of cases, which is the adjustment of status based on marriage. There's obviously a lot that can be said about process. We can talk for hours really, but today we want to focus on the basics. What forms do I need in order to file the adjustment of status based on marriage case? First and foremost, you need to prove that your relationship is real. For that, you file Form I-130. That is meant to prove to the US government that you are living with your spouse, that you're sharing money with your spouse, that you've traveled with your spouse, that you've named her as a beneficiary on your life insurance, that you have joint credit cards, that you've met each other's families, all that good stuff. And so the more evidence that you have, the better. Now, importantly, you don't have to have all the types of evidence that I just mentioned, because couples are different, relationships are different, and that's okay. But just keep in mind that you need to do your best in order to provide the government as much evidence as possible. I will also say that out of all the types of evidence that I mentioned, cohabitation, which is a fancy word for living together, and commingling of funds tend to be two of the most important types of evidence. And so keep that in mind as you're preparing your case. Secondly, the beneficiary is going to have to file Form I-130A in order to provide biographic information about himself or herself to the US government. Thirdly, the I-485, which is the actual green card application, the I-765, application for work authorization, the I-131, advanced parole or travel permit, in order to allow you to travel while your case is pending. The I-864 is the form that the petitioner, the U.S. citizen spouse, is going to be filing with the U.S. government to prove that he or she has the financial means to support the beneficiary. And lastly, the I-693 medical examination report to prove that the person seeking the immigration benefit is not inadmissible for any medical reasons. Now, for the medical report, we tend to include that when we first file the case, but if you don't, you can also take that with you at the time of the interview, which tends to be about 10 to 11 months down the road. And so when we are done putting the packet together, we tend to see packets that range anywhere between 250 to 350 pages. The reason why we work so hard to make the packets as saturated with evidence as possible is because the more we work at the beginning, the easier our job will be down the road. Smooth sailing interviews. Why? Because you did so much work at the beginning of the case. And so I hope that gave you a brief summary of the types of forms that we normally include in filing a marriage-based adjustment of status case. Until next time, take care of yourself.